In what will be described as a comeback move, respondents opposed to the BBI process in a hard-hitting statements faulted the appellants of misleading the Kenyans about the promoters of the constitutional amendments bill by reaffirming it was the executive under President Uhuru Kenyatta and not the politicians Dennis Waweru and Junet Mohammed.
The first theory is that this was an initiative by one Dennis Waweru and Junet Mohammed. That has been submitted. Now I find that to be, for lack of better terms, taking us for a ride.
I urge this court to find that apparently what we are talking about here was a botched attempt to overthrow the people and their constitution at the same time. Luckily, by the grace of the Almighty, the judiciary, through the Superior Court, came and, in my view, rightfully interpreted this constitution.
While making submissions before a 7-judge bench led by Daniel Musinga, lawyers Elias, Mutuma and Kithure Kindiki, acting on behalf of the Thirdway Alliance Party chairperson Miruru Waweru, told the court that President Kenyatta initiated the BBI process in official capacity, which is unconstitutional.
Dennis Waweru swears an affidavit dated on being the Honorable Mohammed Junet, together with Honorable Junet Mohammed, duly authorized to swear this affidavit on behalf of my co-chairperson and on behalf of BBI, Honorable Raila Amolo Odinga, the respondents in this case. My point is, the respondents in that case was not Junet Mohammed, was not Dennis Waweru. We sued them in their capacity as officials of BBI National Secretariat. They never filed a single notice of protest to that description.
According to the legal team, Uhuru Kenyatta will have relinquished the powers as the president and embarked on the constitutional amendments process as a private citizen.
I'll give you an example that happened with this same executive, Your Lordship. In 2014, our president was facing a personal case at The Hague. When he was leaving for that case, which was his personal matter to attend to, he did the right thing. And I believe, under the advice of Emeritus, AG then, Professor Kithure Muigai, he handed over power to the deputy president, appointed him as the acting president, went to The Hague as a citizen, was not received by the state there as a president, but as an individual. So if the president then wants to initiate such a process as a citizen, he must of all do exactly that. Announce to us that this is not the president doing this, it is me as a citizen.
LSK President Nelson Havi, acting on behalf of the 5 activists led by David Ndi, Charotich Sei, James Gonde, Wanjiru Gekonyo and Ekai Angelei, reiterated that President Kenyatta subverted the will of the Kenyans in the formation of a presidential initiative rather than a popular initiative. The lawyers also outlined the reasons why the basic structure of the constitution cannot be altered, with the lawyer Mutuma Thiangol expressing BBI as a big monster. On matters about signature collection, a lawyer Estangawa told the court the electoral body IBC flouted the law by verifying the more than 1 million signatures manually, despite possessing a biometric system to ascertain the authenticity.
Taxpayers pay for the work of the commission. Taxpayers pay for the biometric voter registration. It cannot lie in the commission to come and admit that it does not have that which it says in the act is a unique identifier when we have a biometric voter registration system.
The Court of Appeal is in the home stretch, listening to the BBI case, and by Friday, it shall wind up the proceedings before they retreat to write the judgment. Reporting for Ebro TV, I'm Jeff Khaemba.